Well, we are back to give you the legal edge. Late last month, the Michigan Court of Appeals ruled in a groundbreaking case of criminal responsibility for the acts of a child, saying the parents of a teenager who killed 4 students at Oxford High School will face trial for involuntary manslaughter. Attorney Brian Waldman explains how the court reached that unanimous decision.
The Crumbleys were essentially appealing a decision of the district court judge that probable cause existed to proceed with 4 counts of involuntary manslaughter against them related to the shooting that occurred at Oxford High School involving their son. On appeal, the Crumbleys really focused on something called causation. They said causation is an element of involuntary manslaughter, and the judge made a mistake in ruling that there was this causation or a causal connection between their allegedly grossly negligent conduct and the shooting that occurred at the high school. What the Crumbleys said is the reason there's not causation, there's not this connection between our conduct and the shooting, is because of something the law calls a superseding cause. The actions of someone else that severs that causal chain or causal connection between their conduct and what happened at the high school. Now, generally, intentional acts or criminal acts of another person are considered unforeseeable, and for that reason will sever the causal connection of some negligent or grossly negligent conduct of a criminal defendant or a defendant in a civil case. What the Crumbleys were claiming is that superseding cause was the criminal conduct of their son, who had pled guilty to 4 counts of first-degree murder. And the Court of Appeal said, well, yeah, generally criminal acts are not foreseeable and they do act as a superseding cause. But in this case, your actions, parents, Crumbleys, were so intimately connected with the actions of your son and ultimately what happened at the high school that you're not relieved. And beyond that, it was foreseeable, or a jury could determine it was reasonably foreseeable that with the information available, your grossly negligent conduct led to this shooting. And specifically, you knew that you had an extraordinarily troubled son, but yet you gave him a handgun. And then when presented with direct evidence that he was contemplating causing harm to others, you sat back and you did nothing. And so for that reason, and you have to stand trial for involuntary manslaughter, 4 counts.